on torture, but it is at the same time very difficult to face this audience while torture is a culture in a society where people who believe that without torture the truth cannot be extracted in a criminal investigation system. So in this juncture, I would like to draw certain issues, and especially two cases. One, where I was a lawyer. In many torture cases, I was a lawyer, especially in blast case, in ASK case. The major problem came when 2013 Act was enacted. How it came? One gentleman, he belonged to Jubodal. He was tortured to death in BB custody in Minto Road. His brother came to us, said that how brutally he was tortured. He took snaps of the torture, injuries, and then we filed a writ petition asking for forming an independent inquiry commission headed by a judicial officer, a retired judge. And the division bench took up the matter, heard and said that we understand, you have evidence, but we are unable to entertain this because there is an alternative forum. So the High Court division, having the full autonomy, independence and protection of their service, their jobs, refused to entertain this kind of prayer. When I asked the victim's family to go and file case before the district judge, Metro Session judge, they did not dare to go there. They went to their leaders. The leaders also did not dare to go there to file case against these DB people. This was the unfortunate part we have experienced. So, in this situation, before 2013, we have certain judicial activism. In 1982, we had a very strong case called State versus Bassett. In that case, the confessional statement was not taken into account, as it was alleged that it was a byproduct of torture in custody. Then we had a case in Abdul Malik versus the state in 1995. This 1982 case was developed, and it was ultimately more developed, having the light from the famous D.K. Basu case of Indian Supreme Court. And this case was filed by Blast, and which is called Blast versus Bangladesh. It was in 2003. Then there was another case, Humayun Kabir versus Bangladesh. That is also another judicial activism from our part. And finally, Ask versus Bangladesh in 2010. All these series of cases are part of our judicial activism by the Supreme Court, which had given guidelines against torture. But 2013, by way of an alternative forum, has stopped some sort of judicial activism. And on the other hand, that forum has become one kind of fantas officio, because the victim's family do not dare to go there. They think that if they go there, they may be implemented in different types of cases, pending cases, ghost cases and all these things. And we believe that this culture should be stopped gradually. Overnight, it is very difficult. But nevertheless, in the last 2 months and almost in last 20 months during the interim government as well, we did not get any report regarding the enforced disappearance. In last 2 months, there was no case reported on enforced disappearance. The custodial torture has drastically been reduced in last 20 months, post-August revolution. These are significant developments in our culture, in our jurisprudence, in our judicial activism, and in our social psyche. And with these backgrounds, we would like to say that we have very nice laws, fine laws. Our Constitution, especially Article 35, Sub-Article 5, has incorporated the provisions of Universal Declarations of Human Rights and torture conventions, protocols, and all these provisions that no person shall be subjected to torture, inhuman and degrading treatment or punishment. This is our constitutional mandate by way of prohibition. It's not directory prohibition, a directory provision of law. It is a prohibitory provision which has some sort of obligations upon the government and upon the law enforcement agencies as well. But still, that has become part of our culture. I can give you one example from my past experience. When I was a student of Dhaka University, one day at midnight, one of the sitting judges of the High Court Division called me. His son was a very good human rights activist. He was apparently a very human rights oriented judge. He called me and he asked me to go and meet him at the mid of the night around 2 a.m. in Dhanmondi in front of the house of his father-in-law. I went there and he told me that my wife is being locked by her brothers over a dispute of the property dispute. So his mental issue was he called the police to arrest the brother and torture him. Police refused to do that. It was in the year 1994. Then he asked me, I was a student activist at that time, and asked me to bring some sorts of gundas and to break the lock of the house at that night. I'm telling it because to make you understand what is the social psyche. A sitting judge could encourage these kind of things. Then I told him that if I enter into this house now, it is in road number 6 and the Daily Star office is road number 3. Tomorrow there will be a headline that the judge of the High Court Division has used gundas. Will you defend those people from the university? Then he became shaky. So this is how our society reacts. When they face this kind of thing, they think that we should apply force. We should come out from this kind of social and psychological disease. And then our fine laws, statutes can be applied in a very fine-tuning manner. Therefore, my understanding is that mere enactment of laws may not result may not be a way out to come out of this kind of culture of torture. we have to go jointly to apply the laws as well as to advocate for creating a sensation among the people's mind that these are very inhuman, these are very unbecoming and undesirable procedures to do complete justice to a criminal proceeding. This is how we are thinking about. Again, there was a time we had a issue. We had an issue like, acid throwing. We had very strong laws against that. And the government had taken initiatives not only to implement the laws, but also to make it public that this is a very bad precedence to throw acid to the opposite sides. So now the acids, throwing of acids has been reduced very substantially in the society. We have a law that, which we call that Nari Shishu Nirjatan Dmon Ain, where the women, the wives, can file case easily against the torture caused to them by the husband. It's a domestic violence. But that law is being used and abused in such a manner. Almost 90% of this law is being misused and abused. A wife, when she thinks that her husband, she is not happy in the family, or husband is not listening to her, she goes to the court, file case, not only the husband, against the husband's brothers, sisters, against the mother-in-law, father-in-law, and all these things. And our experience being the practicing lawyer is that more than 90% of these cases are false, and this law is being used like that. We want that the independent body like Human Rights Commission should come forward to look into this issue very strongly. We do not want the culture of impunity. We do not want the culture of violation of human rights in any form. We do not want any custodial death. We do not want any enforced disappearance. We do not want any kind of extrajudicial killings. We know what the pains of these kind of human rights violations are. But still, we understand that your expectations to this government is so high, and we have to go far away. We have to work for a long journey. It's only 2 months. And in these 2 months, as Mr. Mahmood Rahman has rightly pointed out, that it is too high to expect too much from this 2 months government. And we can give you the promise that we will go and work through the international instruments as well as our own domestic laws in respect of human rights. We are sometimes subjected to disinformation, misinformation, and propaganda, yellow journalism, which we are also containing and facing in a very tolerable manner. We are not encouraging filing of cases on digital security issues or applying the Digital Security Act. We are not encouraging that, this government. Rather, this government has followed the footpath of the interim government, where the cases like under Digital Security Act or ICT Act should not be continued for longer period. Recently, we have already instructed some of the public prosecutors on these sectors that do not oppose these kind of cases so seriously, unless you find that it affects any individual's personal integrity, like a woman's modesty, a girl's modesty, or seriousness which has caused or lead to commit serious kind of crimes like threat to life and all these things. This is our government policy, and we have not. You can give us some good example that government has applied these laws in such a manner. I can assure that I can interfere there through our prosecution team. That is how we want to go through, and we expect that we will welcome any kind of suggestions, good suggestions from you. It may be lengthy, it may be delayed, but it will be implemented gradually. That is our commitment. One question has been posed by one of our participants here, that whether compensations will be given to the victims of torture who are subjected to torture in last 15 years. That is under our consideration. That is under our consideration, but you have to think at the same time that after this government had taken the power, post-election power, we have been facing serious crisis in respect of different angles, like the Iran war. On our economy, there is a very pressure, and we want to face this pressure as well. At the same time, we have taken into consideration of these things. We have taken some pro-public initiatives like family card, Kishok card, and also taken some sort of initiatives like, as I was speaking to Mr. Mahmood Ram, that tomorrow we are going to pass a law that all kind of tax-free import of cars for the members of parliament and of the ministers, those will be prohibited or repealed. We are going to pass this law tomorrow. I am going to place this tomorrow before the parliament, and I hope that the whole parliament will pass it unanimously. We have taken initiative that the ministers' facilities for fuel in every month should be reduced 30%. And we have also declared that the allocation of plots for the MPs and ministers should be stopped forever, which was initiated by none other than Mr. Adilur Rahman Khan during his tenure as the minister, advisor of that ministry. We are following that path as well. In our first meeting, our Honorable Prime Minister has declared that this should be continued and this should be stopped forever. We are taking some sort of good initiatives. You should stand by these initiatives as well to encourage us. At the same time, you should be working like a watchdog to guide this government, to force this government to go in the right path. And we will welcome you always to such kind of pressure. Thank you very much. Thank you once again.